Welcome to LawFest 2020 and to the first Q&A session. I'd like to begin by acknowledging the traditional owners and custodians of the land on which each of us are sitting today. In my case, the Playa Heka Phillipa people of the Burnie region, where Jan and Phillipa are the Muanina people of the western shore of the Derwent estuary. Wherever you are in the state, we're on Aboriginal land, and we acknowledge the traditional owners and express our great appreciation and admiration for their ability to have survived not only violent dispossession, but all sorts of natural disasters, as well as man-made ones that have been imposed upon them. And we thank them, our Tasmanian Aboriginal community, for preserving their cultural, legal and spiritual traditions as effectively as they have. This first session is on natural disasters and international legal regulation. Just a couple of housekeeping notes before we get started on question and answer. Firstly, microphones, video, chat and raised hand functions have all been disabled to protect your privacy. If you encounter any technical issues, you can communicate with the panel using the Q&A function. The webinar is being recorded. Some people in legal studies classes around the state aren't able to watch in live and will watch it later on, but you're not being recorded in any way. Just want to thank you for all the great questions that have been sent in through your legal studies teachers, and we're going to try and answer as many of them as we can. If you've got any other questions, either related to the panel specifically, but also more generally about the study of law, then please join Dr. Matt Killingsworth and I at 3:30 this afternoon. It's a pleasure for me to introduce two of my colleagues, Professor Jan McDonald and Dr. Phillipa McCormack, both of whom have done wonderful pre-recorded presentations for us, Jan, on the issue of sea level rises, coastal inundation and climate change effects on the coastlines of Australia, and Phillipa on bushfires, loss of biodiversity and habitat, and natural disasters of that kind. Jan is a professor in environmental law. She's currently teaching a unit in the law school called Current Issues in Environmental Law and Policy. She specialises in legal and policy dimensions of climate change adaptation and intervention, and has a global reputation for her expertise in that subject matter. She works with local state governments and is on the board of Environment Australia. Phillipa teaches public law. She's currently teaching administrative law in the LLB. She also coordinates our honours program in our law degree, and also coordinates a parliamentary law and practice course that we teach to parliamentary staff. Phillipa's PhD was on biodiversity and international legal regulation, and she's researching in the field of climate change adaptation and Australia's conservation laws. Let's get stuck into some questions. First one for Jan from Rosny College. What recommendations do you think the Royal Commission into Natural Disaster Arrangements might make?
Thanks, Tim. So we've got a little bit of an insight into what the Royal Commission might make recommendations about, because they actually, very conveniently for us, released an interim report only 4 days ago on Monday of this week. And I think what's interesting about the interim report is as much what it doesn't talk about as what it does talk about. So bear in mind from the beginning what the terms of reference of this inquiry were. They were to look at how the federal government coordinates with other levels of government, resilience to climate change and mitigating disaster risk, and the laws governing the federal government response to national emergency. So the things that the Royal Commission is likely to make recommendations on are going to be influenced by those terms of reference and the scope of the inquiry. The interim report is obviously only very preliminary. You know, there were hundreds and hundreds of submissions to the Commission, both written and now through oral hearings. We've only got a 25-page, very summary interim report at the moment. And I think it was partly to sort of recognise that the final report is going to take a little bit longer than was expected, and so people want to get a sense of what the thinking of the Commission is. But it talks about some really pressing needs. First of all, around information and data, and the need to both collect and harmonise and then share disaster data more effectively across jurisdictions, across state jurisdictions. There's acknowledgement that our current aerial firefighting capabilities are not going to perform adequately under the new normal, and we need to really seriously reassess those capabilities. And some broader comments about the need for more effective planning around critical infrastructure. It recommends, perhaps not surprisingly, a stronger federal role, both in relation to disaster response, so immediately around a particular event, but also in relation to longer term recovery and resilience. And it's a very welcome thing to see that the Royal Commission is separating those two things out. They are quite different. One's about immediate emergency management. One is about longer term planning that feeds into prevention of future disasters and improving resilience to future disasters. So first, it suggests that the current arrangement that we've got in relation to response, which is this organisation known as the Australasian Fire and Emergency Services Authorities Council, or AFAC for short, gets transferred to a federal government agency. At the moment, it's a non-government organisation that consists of all of the state-based agencies, and it's responsible for facilitating deployment of all of the emergency personnel and equipment internationally and interstate. It's going to be interesting to see whether the states respond favourably to a suggestion that they give up their engagement and have it nationalised and move towards a central body. The second thing that the report recommends is consolidating the recovery and resilience arrangements into another new national body. At the moment, what we've got is Emergency Management Australia, the National Bushfire Recovery Agency, the National Drought, and the National Northern Queensland Flood Response and Recovery Agency. Kind of a lot of different entities there that purport to be national, but are all doing sort of similar things, but under different auspices. What's being proposed is a new disaster recovery agency that would help strengthen resilience to future events. And this has the benefit of getting a sort of a whole of government approach, provided it's done effectively. So there's some significant governance and institutional recommendations that seem to be bubbling out of those recommendations at the moment. But I want to just touch on very briefly some really key things that it hasn't said anything about so far. First of all, it hasn't really reached a clear view about what the implications would be of the Commonwealth declaring a national state of emergency or expanding those state of emergency powers of the national government. It recognises that the national government can do that, but at the moment it doesn't really have very much more than just sort of symbolic force. It also really doesn't say anything much about land management practices. You know, backburning has been a very big issue, and it really doesn't say very much about that other than to say that the laws are very complex. And along the same lines, it doesn't really say very much at all about the impacts of the 2020 bushfires on wildlife. It talks about the fact that it simply highlights the need for action to ensure greater consistency and collaboration in the collection of information. So it's pretty weak. And perhaps most strikingly, but also not surprisingly, it really says nothing at all about the need for Australia to take stronger action on climate change and to ramp up its mitigation commitments. I personally hope that that's an omission that gets addressed in the final report, but given that the terms of reference don't ask it to address that issue, it's perhaps not surprising that it hasn't dealt with it. Back to you,
Thanks.
Tim.
Thanks for such a comprehensive answer. I really appreciate it. So second question for you, Jan, from Rosny, at college again, is could courts significantly change the law around responses to climate-related natural disasters through the creation of new common law precedents?
Yes, it's a really interesting question, and Australia is seeing a little bit of a burgeoning of environmental litigation at the moment that's beyond the traditional litigation that we've seen, which is things like challenging new coal mines and sort of more what's described as more old-fashioned mechanisms for trying to drive change. In theory, there are some really important issues that the courts could contribute to developing or changing. For example, the United States has got this common law doctrine called the public trust doctrine, which originates in the United Kingdom under English law, but Australia hasn't adopted this public trust doctrine. The public trust doctrine is interesting because it recognises community rights in things like public beaches and foreshores that have experienced coastal erosion, and they would drive policies around adaptation in response to coastal erosion. So recognising the public trust doctrine in Australia and applying it to climate-related coastal impacts would really change the dynamic between private beachfront property owners and local councils and state governments in relation to sea level rise and coastal risks. Similarly, a few years ago, a group of beachfront property owners in New South Wales around Byron Bay sued the state government, claiming that planning laws were restricting their common law right to build seawalls that would protect their private property from the sea. And they were asserting that there was this ancient common law right to protect their property from the sea. That action ended up being discontinued, so we didn't get any authoritative statement from the New South Wales courts about whether or not such a right actually exists in Australian common law. But it's another example of where the court could have reached a decision that had wider significance. And just finally, the other field where the courts could potentially help drive better responses to climate change is in the rules relating to causation. So at the moment, it's very difficult for anyone to show that the damage that they've suffered from a particular extreme event is caused by climate change, or that a particular emitter has contributed to climate change, which then contributed to this particular extreme event. And it's because of the way in which the courts require proof and the definitions of causation. If the court started to accept and apply this emerging concept of attribution, the science of attribution, which doesn't talk about, yes, this event was definitely caused by climate change, but the chances of an event like this occurring because of climate change are now 100 times more likely. If the courts took that kind of approach to proving or being satisfied of causation, it would very significantly alter the dynamic around holding emitters to account and holding governments to account. And that would see a shift in the levels of responses. Whether we see those shifts, however, although they're theoretically possible, I think so far what we've seen in Australia is very, very conservative approaches to having common law interventions from the courts. So I think that we're not likely to see this kind of development, and we're more likely to see the court saying this is a role for Parliament to enact legislation to address.
Great, thanks very much. Phillipa, for you, a question from a student at your old college, Elizabeth College in North Hobart. If coronial inquest, you made the great suggestion in your pre-recorded lecture that we could possibly have a coronial type inquest when a species is extinct, to learn lessons from how that happens. So question from the student is, if coronial inquests were to be implemented, could the loss of species and habitat, both of which are supposed to be protected by conservation laws, offer an opportunity for government to be held accountable in lowering greenhouse gas emissions or otherwise protect the environment from further climate change effects?
Thanks, Tim, and thank you to the students who asked this question. I'm deeply sympathetic to it. It's a great question, because if we're not going to respond to climate change through clear, explicit legal regulation of emissions, maybe we can find a backdoor. And unfortunately, the very quick answer is no. I really don't think that that's first of all, I don't think it's an appropriate mechanism, because it's not really what it's about. But secondly, I don't think that it will work that way, because with inquests, royal commissions, other forms of inquiry, the recommendations that they make are not legally enforceable. They're important. They provide information to decision makers and lawmakers. They inform the public about what's going on, but they're not legally enforceable. So anything that they say about greenhouse gas emissions is not going to sort of have legal effect. But just in sort of wrapping up my answer to that question, I think that what they can do is when we lose a species to extinction at the moment, sometimes it happens under the radar. And I think bringing the fact of species loss to the forefront of our minds through an inquiry or an inquest, public reporting mechanisms, and then reporting by the media gives us the opportunity to see what we're losing as we go along. And what I hope is that would trigger lawmakers to act in a much more explicit, appropriate way to the effects of climate change.
Thanks, Phil. I really appreciate the proposal in the lecture, and thanks for the answer to the question. The second one for you, this time from Claremont College, a little bit further up the river, the Derwent River, that is Bob Brown's, and not directly related to the content of your lecture, but an interesting question nonetheless, is Bob Brown's recently announced challenge in the federal court to native forest logging in Tasmania likely to succeed in halting the practice?
So I also really love this question, and I think that the further that we go through our study of the law and our working in the law, the less confident I think we feel about calling a judgment before the court actually decides the matter. And so I can't tell you what the outcome will be, unfortunately. What I would say is two things. First of all, I think that the demise of native forest logging is inevitable in Australia. We know, for example, that markets are looking for sustainable certified timber, and both Tasmania's Sustainable Timbers Tasmania and Vic Forests, which is the Victorian statutory agency responsible for native forest logging in that state, have failed to achieve that accreditation. And so the market, I think, is shifting so that native forest logging will become less and less financially viable. But I think that the other side of that is whatever the outcome is from that case, I suspect that it won't overturn the regional forest agreements. We don't have time to go into the legal framework, although I would love to tell you all about that. But I think that the point that I would make is what we might see from a piece of litigation like this is a really close investigation of the way that logging and forestry operations are some of the biggest threats to habitat, or some of the biggest causes of habitat loss. And habitat loss is one of the biggest threats to our endangered species. And as habitat is lost to fire or to sea level rise in the context of kind of salt marshes and mangrove forests and so on, lost to big storms and erosion and so on, habitat protection becomes a much more critical issue. And so litigation like this brings that dichotomy right to the fore. And so, yeah, I really hope to see change in that, but I don't know that this case is going to be the thing that really turns it all around.
Thanks very much. We're at 11:54 and we absolutely have to finish this session on or before 12 o'clock so the next one can start. So let me pose this question to both of you, also from Rosny College, and let's see how we go answering it. Hopefully, if we get to 11:59, I might just have to stop midstream. But which Australian laws do you think need to be reformed most urgently in order to improve Australia's legal response to climate-related natural disasters?
So I'm going to jump in, Jan. I hope that's okay. And if you want to add to it, then please do. I'll try and do it really quickly. And I think that, so Jan and I had a conversation about this question, and so we decided I'd take point, but she and I sort of agreed, I think, about the way to respond to it. And the first thing is the person who has asked the question, it's not necessarily clear whether we're talking about immediate response or kind of long-term response. And Jan already talked in one of her answers about this idea of the immediate response to extreme events being pretty well covered. We've got a legal framework for emergency responses that focus first on human life and safety and then on property. And to some extent, we are shifting in terms of practices under those immediate emergency response laws to take better account of biodiversity and conservation, habitat, and so on. So in terms of those laws, there are some opportunities for reform, but I think that's probably not where our biggest challenge lies. And I think just based on the conversation that we've had today, it's pretty clear that the big change that we need to see in terms of urgent reform to improve Australia's response generally to climate-related natural disasters and extreme events is that we really need to create laws that impose a statutory obligation on decision makers, government from federal, state, regional and local levels, to ensure that all of the decisions that they make in relation to health, finance, transport, infrastructure, planning, the environment, tax, all of these things need to advance the Paris Agreement target of keeping temperature, global warming to 1.5 degrees. And the obligation that Australia and Australian jurisdictions must adapt to the changes that we're seeing and prepare for the changes that we're going to see. And they're going to be severe and it's going to be hard. And unless we plan, unless we have laws in place that demand that our decision makers help us plan, we're just not going to do that well. So we urgently need a whole framework that demands that climate change be part of decision making across the board. Jan, I think you've got a minute.
You could take two if you want to, Jan.
You know, as I said, Phillipa and I discussed it ahead of time, so she's reflected the views that I already had. So, you know, of course, having that kind of law reform requires the political will to enact that law reform. And while laws can drive political change, you still need an element of political will in order to get the laws in place in the first place. So, you know, it's a call to all of you to not be complacent and fight the good fight.
Thanks so much to both
Everybody
of you.
Vote.
Yeah, you said that in your pre-recorded lecture. Look, I watched both those lectures, and I thought they were fantastic. I learned so much myself, and I'm very grateful to both of you for the work that you did in preparation for today, and also for the great answers that you provided to the few questions that we've been able to deal with. Obviously, there were additional ones we didn't get to. And sorry to the students who asked them, but yeah, come and study law with us and let these two inform you on way more detail than they've been able to today. Thanks heaps, Jan and Phillipa. All the best.